नमस्कार दोस्तों, रैंकर्स क्यू में आपका स्वागत है। आज मैं आप लोगों को लीगल डिक्टेशन प्रोवाइड करने वाली हूँ, सो गेट रेडी फॉर द डिक्टेशन। The factors set out in the first part of section 90 are from the point of view of the victim. The second part of section 90 enacts the corresponding provision from the point of view of the accused. It envisages that the accused too has knowledge or has reason to believe that the consent was given by the victim in consequence of fear of injury or misconception of fact. Thus, the second part lays emphasis on the knowledge or reasonable belief of the person who obtains the tented consent. The requirements of both the parts should be cumulatively satisfied. In other words, the court has to see whether the person giving the consent had given it under fear of injury or misconception of fact, and the court should also be satisfied that the person doing the act, that is, the alleged offender, is conscious of the fact or should have reason to think that but for the fear or misconception the consent would not have been given. This is the scheme of section 90, which is couched in negative terminology. This court, while deciding Pradeep Kumar Burma within bracket Supra, placed reliance upon the judgment of the Madras High Court delivered in N. Zaladu re ILR within bracket 1930-36 453, wherein it has been observed. We are of opinion that the expression under a misconception of fact is broad enough to include all cases where the consent is obtained by misrepresentation. The misrepresentation should be regarded as leading to a misconception of the facts with reference to which the consent is given. In section 3 of the Evidence Act, illustration within bracket D states that a person a certain intention is treated as a fact. So, here the fact about which the second and third prosecution witnesses were made to entertain a misconception was the fact that the second accused intended to get the girl married. Thus, if the consent of the person from whose possession the girl is taken is obtained by fraud, the taking is deemed to be against the will of such a person. Although in cases of contracts a consent obtained by coercion or fraud is only voidable by the party affected by it, the effect of section 90 IPC is that such consent cannot under the criminal law be availed of to justify what would otherwise be an offence. Hence, it is evident that there must be adequate evidence to show that at the relevant time, that is, at initial stage itself, the accused had no intention whatsoever of keeping his promise to marry the victim. There may of course be circumstances when a person having the best of intentions is unable to marry the victim owing to various unavoidable circumstances. The failure to keep a promise made with respect to a future uncertain date due to reasons that are not very clear from the evidence available does not always amount to misconception of fact. In order to come within the meaning of the term misconception of fact,